Well, it is noon, and I want to say good afternoon and welcome to another installment of our ongoing nonprofit leadership and engagement education series. I am Joanne Nazer, Manager of Nonprofit Leadership and Engagement at the Washington County Community Foundation. Thank you for joining us today to learn from our content expert about revised salary levels for exempt employees. I am very pleased to introduce Katie Ainsworth, Esquire, Executive for Corporate Administration with Southwestern Pennsylvania Human Services, or SPHS. Thank you, Katie, for presenting today. Feel free to begin.
All right, great. Thank you, Joanne, and thank you to the Washington County Community Foundation. And thanks everyone for logging in this afternoon. As Joanne said, we're here today to discuss the overtime rules contained in the Fair Labor Standards Act and the recent and upcoming changes to those rules. So just the agenda for this afternoon. First, I'll talk a little bit about myself and my background, as well as SPHS. Then we'll do an introduction to the Fair Labor Standards Act, what is considered overtime, as well as the exemptions for employees who do not qualify for overtime, how to comply with the rules, what counts as hours worked under the Fair Labor Standards Act, so that we're making sure we're accurately capturing hours in order to pay overtime correctly, what the penalties that could be assessed if you violate the Fair Labor Standards Act, as well as the recent increases to the salary thresholds. Okay, so first, just a little bit about me. I am a graduate from the University of Miami School of Law. Before that, I did my undergrad at Pitt in political science and history. After law school, I practiced law in Miami for a few years and then moved back to Pittsburgh, where I found a job with a nonprofit in the city that eventually I started doing compliance for that organization. In 2015, I left that job to come to SPHS as the Director of Quality, Risk Management, and Compliance. Eventually, I was promoted to Executive for Corporate Administration and General Counsel. So I do the legal work, still do compliance, and I oversee our HR department as well. So if you're not as familiar with SPHS, it started as the Mon Valley United Health Services. And it was created because at the time, residents of the Mon Valley, in order to receive services, had to go to the county seats, such as in Washington and Greensburg. So they started this initiative in order to bring health and human services closer to home. The mission now of SPHS is to identify and provide for health and social services needs throughout the entire southwestern Pennsylvania region. So the agency grew into 9 corporations altogether, the parent and our 8 affiliates. We currently serve 6 counties in the region: Armstrong, Butler, Fayette, Greene, Washington, and Westmoreland. And some of what we do, so like I said, SPHS is the parent corporation. So our organization holds all of the administrative functions. So we perform the administration for our affiliates. So that's our finance department, HR, IT. We also have the Monessen Family Center in Monessen that does some services. Our organization, Connect Incorporated, does our housing services. They serve Washington, Westmoreland, and Greene counties. They have homeless shelters in Greensburg and Washington, as well as a host of other housing projects to serve the homeless and homeless populations. The Southwestern Pennsylvania Area Agency on Aging is the area agency on aging for Washington, Fayette, and Greene County. It is the 3rd largest AAA in the state of Pennsylvania, behind Allegheny and Philadelphia, so quite a good size organization serving seniors in the region. Southwest Behavioral Care and the Care Center are our behavioral health organizations. They provide a variety of substance use, mental health, and other behavioral health programming to all 6 counties that we serve. Mon Valley Community Health Services hosts our Center of Excellence in the Mon Valley, as well as provides the WIC services for Westmoreland County. The Mental Health Association in Butler County has a CompPeer program, as well as rep payee services. And Diversified Human Services has our child care centers, aging services, as well as developmental services for adults with IDD. And Comprehensive Community Services is our final affiliate, and they function more in a property management position, housing our maintenance work and things like that. Because of the size of our organization and the complexity of the corporate makeup, overtime is particularly challenging for us, even though we are 9 different organizations with different EINs. Because we have this parent affiliate structure, we are considered one employer. So we have employees who will hold 2 or more jobs within the agency, whether it'll be with one affiliate or 2 or 3. That's all looked at as one employer. So we have to make sure that if somebody works a full-time job in one organization and a part-time job in a second, they're likely going to go into overtime. And so we have to make sure we're keeping a watch on those hours so that they are being paid correctly for that overtime pay from the correct organization, as well as just keeping track of those hours. As you can imagine, it can be quite challenging with the number of employees we have, the number of jobs we have, and we do have a lot of employees who hold 2 or more jobs within the agency. Okay, so now we'll get into the subject of the presentation, the Fair Labor Standards Act, and the overtime rules in particular. The Fair Labor Standards Act is a federal law that sets standards for minimum wage, overtime pay, record keeping, and child labor. It applies to both private and public sector employees, including full-time and part-time workers. The FLSA was passed in 1938 during the Great Depression, and the U.S. Department of Labor's Wage and Hour Division enforces the FLSA. The FLSA includes both civil and criminal sanctions to ensure employers' compliance with the regulations. Most private and public companies are covered by the FLSA. Covered companies which must have at least 2 employees are any that their annual gross volume of sales made or business done is not less than $500,000, or they are engaged in the operation of a hospital, an institution primarily engaged in the care of the sick, the aged, or the mentally ill who reside on the premises, a school for mentally or physically disabled or gifted children, a preschool, an elementary or secondary school, or an institution of higher education, whether or not they are nonprofit or for-profit, or any public agency. In addition to employers that are covered, employees themselves might still have protection under the individual coverage test if those employees engage in their work regularly involves them in the commerce between states, so interstate commerce. So this language might sound a little confusing or even a little narrow, but it's actually quite broad. So any employer with 2 or more employees whose budget is around or above $500,000 should really make sure that they are aware of the rules under the Fair Labor Standards Act and complying with the rules to the best of their ability. Next, we'll talk about overtime, get into the heart of that, and last exempt, which will talk about the different exemptions to the overtime rule. Employees covered by the Fair Labor Standards Act, which again covers most employees, must receive overtime pay for hours worked over 40 hours in a work week at a rate not less than time and a half of their regular rates. There is no limit, however, on the number of hours employees who are over the age of 16 and older may work during a work week. So there's no actual cap on the hours they can work. It's just anything over 40 has to be compensated at time and a half. It's also of note that there are no specific days or dates that require overtime. So somebody may be assigned a weekend or a holiday to work, but as long as they are still under 40 hours a week, they're not entitled to overtime pay. So you might have specific policies in place. We operate 24/7, 365. So we have people work every weekend, holidays, and we have policies where they get holiday bonuses, other incentives, because as you can imagine, those are hard shifts to staff, but the law does not require any kind of overtime pay or extra pay unless they're over 40 hours. Also, if your pay or if your full-time policy is less than 40 hours a week, so for most of our employees who are office-based, our residential is a little bit different, but any office-based employees, our full-time policy is that we work 37.5 hours a week. So before we get to that 40, but over the 37.5, so for us, it's 2.5 hours. If a full-time employee who is not exempt works over that 37.5, they need to be paid their hourly rate. That up until 40, it can just be straight time. And then after 40 is when it's required to be time and a half. Overtime is calculated on a work week basis. An employee's work week is a fixed and regularly recurring period of 168 hours or 7 consecutive 24-hour periods. A work week does not need to coincide with the calendar week, but may begin on any day and out any hour of the day. For simplicity, we use 12:01 on Sunday through midnight of the following Saturday, but you can start your work week um, any day of the week as long as it's consistent and it consists of 7 consecutive days. We have a union in our organization, and we recently changed it with the most recent contract, but we actually did have them start their work week started on Monday, whereas the rest of our staff, their work week technically starts on Sunday. You should try to select a work week that works best with your pay schedule. So we recently, this past year, switched to being paid every other week. Before that, we were paid bi-monthly, and that itself can create some challenges because a pay period then encompasses usually a little bit over 2 work weeks. We also have people earning their overtime on a work week that actually is split into 2 pay periods. So if you're not on a bi-weekly or weekly schedule, making sure that payroll is aware and paying correctly for those overtime hours, and that typically should be paid during on the paycheck for the pay period when it was worked. You can use different work weeks for different groups of employees. Like I said, we used to have 2 different work weeks. And it's important to know that you can't average hours over 2 or more weeks. So if you have a week where there's a board meeting or something where people have to stay late, they work 45 hours that week, you can't make up for it by having them work 35 the next week. If you want to cut 5 hours somewhere else during the that work week to get them back down to 45, that's fine, but you can't average say 80 hours over 2 weeks. It has to be 40 hours per work week. So like I said, we'll now talk about the exemptions. This is one of the trickier parts, is making sure that you are categorizing your employees as either exempt or non-exempt, because getting it wrong can cause some consequences to arise. The Fair Labor Standard Act allows an exemption from the overtime rules for certain employees who are in the executive, administrative, professional, or outside sales, as well as certain computer employees. To qualify for an exemption, employees generally have to meet certain tests regarding their job duties and be paid a salary basis of not less than $844 a week. Job titles, this is important, do not determine an exempt status. So in order for an exemption to apply, The employee's specific job duties and salary must meet all the requirements of the department's regulations. So the first exemption is the executive exemption. And in order to qualify for this, in addition to making $844 a week, the employee's primary duty must be the managing of the agency or managing a customarily recognized department or subdivision of the agency, so your management team. The employees must customarily and regularly direct the work of at least 2 or more other full-time employees or their equivalent, and the employee must have the authority to hire or fire other employees or the employee's suggestions and recommendations as to the hiring, firing, advancement, promotion, or any other change of status of other employees must be given significant weight. The job duties for the administrative exemption includes the performance of office or non-manual work directly related to the management or general business operations of the employer or the employee's customers. And the employee's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. The professional exemption, there are 2 types of professionals, the learned professional and the creative professional. To qualify as a learned professional, the employee must meet the following tests: that they make not less than $844 a week, that their primary duty must be the performance of work requiring advanced knowledge defined as work which is predominantly intellectual in character and which includes work requiring the consistent exercise of discretion and judgment. The advanced knowledge must be in a field of science or learning, and the advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. The creative professional is an employee whose primary duty must be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. For computer employees, so this might be where your IT department could fall, the exemption also is those who make less than $844 a week, or for computer employees, they also add in, if they are paid an hourly wage, that they're not to make less than $27.63 an hour. The employee must be employed as a computer systems analyst, computer programmer, software engineer, or other similarly skilled worker in the computer field, performing the duties of application of systems analysis techniques and procedures, including consulting with users to determine hardware, software, or system functional specifications. So pretty much anyone in the IT department that helps the end users out. The design, development, documentation, analysis, creation, testing, or modification of computer systems or programs. The design, documentation, testing, creation, or modification of computer programs related to machine operating systems, or a combination of those duties. The outside sales exemption applies if the employee's primary duty must be making sales or obtaining orders or contracts for services or use of facilities in which compensation will be paid to the client by the client or customer, and the employee must customarily and regularly engage away from the employer's place of business. So a traveling salesman, someone who doesn't do sales at their desk, does sales out in the field. Now that's all the exemptions listed in the FLSA. If you've noticed, they all kind of have something in common in that they are all white-collar jobs. Generally, besides management, blue-collar workers who perform work involving repetitive operations with their hands, physical skill, and energy do not qualify for an exemption, no matter how much money they make. So blue-collar workers are entitled to overtime regardless of their salaries. Additionally, the exemptions also do not apply to police officers, detectives, deputy sheriffs, state troopers, highway patrol officers, investigators, inspectors, correctional officers, parole or probation officers, park rangers, firefighters, paramedics, emergency medical technicians, ambulance personnel, rescue workers, hazardous material workers, and similar employees, regardless, again, of their rank or pay level. So in order to comply with the Fair Labor Standards Act overtime rules, the first thing you're gonna wanna look at is what's a little bit easier to define, and that's how much your employees are paid. So you're gonna wanna categorize those who make more or less of than $844 a week, or that comes out to $43,888 a year. A uniform compensation scale can help ensure that you are correctly categorizing your employees. We have pay grades with the compensation scale set by our board of directors, and we just categorize those pay grades as exempt or non-exempt. As you can imagine, some employees who have been here for a long time with annual wage adjustments, they might be in one of the lower pay grades, but actually make more than the threshold. But to keep the guessing game out of the hands of our payroll staff and just to try to prevent any errors, we just keep those pay grades as whether they are exempt or non-exempt. Then it's really important to review your job descriptions for those who make, for job descriptions, period. You want to make sure they're accurate. It helps also in other types of hearings, but for this situation, specifically for those who make more than the threshold that you believe could be in an exempt category, you're going to want to make sure that you are reviewing the job descriptions and making sure that they are accurate. The Wage and Hour Division, as well as other employment law enforcement agencies and courts, will look to the actual duties performed, not those listed in the job description. So just because you write the job description to meet the requirements of the exemption, if those aren't the duties being performed, say you can't call somebody a supervisor, but they don't actually supervise anyone and fall in that executive exemption. Fitting an employee into an exemption by having an inaccurate job description could be looked at as a willful violation of the Fair Labor Standards Act, which we'll talk about enforcement in a little bit. But making it a willful violation does increase the penalties as well as allows them to use criminal sanctions against you. So once you've determined who is entitled to overtime, it's important to make sure then that you are accurately capturing the hours that are worked. As I mentioned before, you're going to want to set a 7-day work week. So this is important, especially if you do have staff who work weekends, making sure everyone knows when their week begins, when their week ends, and then have the timesheets that reflect those work weeks. I do recommend having anyone who qualifies for overtime fill out a timesheet, even if they are salaried, unless you know for certain that they will not ever work over 40 hours a week. It just makes it better for record keeping purposes and to make sure that nothing gets overlooked. Problems can arise when an employer fails to recognize and count certain hours worked as compensable hours. For example, an employee who remains at their desk during lunch and regularly answers the telephone, or more common, they look and check their emails, respond to emails during what should be their lunch break. That time, if the employee is not exempt, should be counted and paid because the employee has not been completely relieved of their duties. So even though they are on their lunch hour, if they are engaging in work, it is considered hours worked and must be paid. Breaks that are considered short, they generally say 20 minutes or less, are considered hours worked. However, bona fide meal times of typically 30 minutes or longer are not considered hours worked, and don't need to count towards those overtime calculations. So these are kind of just examples. Obviously, then what do you do for a 25-minute break? I think you're just going to want to use your best judgment, but always err on the side of caution. And if they're not fully disengaged, then you're going to want to count those times as hours worked. If you have employees who do on-call, it's very important to make sure you know what type of on-call they are doing and paying them correctly. Employees who must remain on the agency property or other assigned locations while on call are considered working. Employees who are allowed to go home or a location of their choosing are not considered hours worked. However, if they are at home and they take a call and they need to go out into the field, back to the office, somewhere to address the concern, obviously that time will be considered hours worked. So you'll want to make sure that your on-call policies follow the Fair Labor Standards Act and that they are paid accordingly for whether they're work hours or just on-call, passive on-call hours. Also note, employees who work outside of assigned hours without permission must be compensated for those hours worked. Our policy is that overtime requires permission from the executive director of the given agency. However, if somebody decides to work overtime, even without permission, we are required to pay that person. So, as you can imagine, that gets a little tricky, doesn't seem fair. You know, we have not given them permission. We don't expect them to be there. They did it on their own. It does not matter. So in that instance, you're going to want to look at your progressive discipline policy for any employees who are doing unapproved overtime or abusing the overtime policies. For lectures, meetings, and trainings, attendance at these do not need to be counted as hours worked, only if it is outside the normal hours, voluntary, not job related, and no other work is concurrently being performed. All other hours need to be considered working hours. So pretty much as long as the training is in connection to their job, they were assigned to go there, they must be paid for that time. It's only in these very limited circumstances where they take it upon themselves to do a training on their own volition voluntarily and on the weekend or sometime that's outside of their normal hours. Travel time can be a little tricky too. Whether or not travel time is considered compensable depends on the type of travel. So the home to work, the regular commute is not considered work time. However, a one-day assignment in another city, time spent traveling to a city different from where their normal office is located is considered work time, except you are allowed to deduct the amount of time that they would have spent on their normal commute from those hours. So it's similar to if you pay mileage for your employees. You don't pay mileage for their commute into work, or if they start their day in a different location, say their regular commute is 10 minutes and it's only 2 miles, but they go somewhere that's 10 miles and 30 minutes, then you pay them that 20 minutes the same way you would pay that extra 7 or 8 miles that they drove. Travel as job duties. So if you have multiple locations and you have employees who drive in between those locations, that time between site is considered work time. Again, too, if they travel what would normally be considered their lunch hour, but they're driving between sites, that would be considered work time. And then any travel time for overnight conferences or trainings is compensable if done during regular work hours. So between 9 to 5, if they leave after work, it doesn't necessarily need to be reimbursed. And even if it's on a weekend or other typical day not worked, if it still falls within those work hours, it is compensable. And the time away from home during regular working hours is considered work time. And why this is important to make sure we're doing what we can to comply is that the fines and penalties for violating the Fair Labor Standards Act can be pretty costly. Employers who willfully or repeatedly violate the minimum wage or overtime pay requirements are subject to a civil money penalty up to $1,000 for each violation. And any willful violations of the Fair Labor Standards Act can result in criminal prosecution and the violator fined up to $10,000. A second conviction can also result in imprisonment. So that's why I mentioned before with the job descriptions. Yes.
Katie, sorry to interrupt,
Go ahead.
but there was a question, and I thought maybe just to take it when you were talking about it. How do you calculate the travel time if the employee does not clock in like you've directed them to?
Again, you're going to want to look at your progressive discipline. So if they're not tracking their time correctly, that's something you're going to need to work with the employee. You can then do something like Google Maps, determine what would be the typical length of time from the two locations. Your HR department should have everyone's home address on file, so you would be able to, determine if they were coming from home, how, approximately how long that would take, and work with it that way. But you're absolutely going to want, we don't want to punish employees for trying to do right by us. They might think they're doing us a favor, but we can get in trouble. So you're really going to want to educate the employees on the importance of filling out timesheets or clocking in and out on their phone or however they're able to do that. So we're paying them correctly. But yeah, unfortunately, that's something you'll have to work out with them. But my suggestion, if they still will not put it in, because regardless, you are required to pay it. I think Google Maps or a similar application can give you kind of an idea of approximately how long. I don't think any wage and hour division employee is gonna hold you accountable if it took them 2 minutes longer than what the average time would be. So that's how I would go about that.
Thank you, Katie.
Mhm. So in addition to the fines and penalties, if it's determined that an employee was due overtime pay that they did not receive, the employer must pay back wages. So the methods which the FLSA provides for in recovering unpaid minimum and/or overtime wages is that wage and hour may supervise a payment of a payback. The Secretary of Labor may bring a suit for back wages or an equal amount for liquidated damages. So if a lawsuit ensues, you might be on the hook for more than just the back wages. An employee may file a private suit for back pay and an equal amount in liquidated damages, as well as their attorney's fees and costs. The Secretary of Labor may obtain an injunction to restrain any person from violating the FLSA, including unlawful withholding of proper minimum wage and overtime pay. An employee should be noted that an employee may not bring a suit if he or she has been paid back wages, or the Secretary of Labor has already filed suit to recover the wages. Mistakes happen. As I said, one of the complicating factors in our agency is that people hold multiple jobs. And a supervisor might have a full-time employee who takes on a job at night that they might not even be aware of. And we've had those instances where we realized somebody should have been being paid overtime and it was just an oversight. We missed it, went back to the best of our ability using timesheets, using the information we could gather, and then paid them the money that they were owed, before it got to a situation where were looked at as willfully violating or even unwillfully violating the act to make sure that our employees were made whole. There is a 2-year statute of limitation to the recovery of back pay, except for in the case of a willful violation, in which the statute is for 3 years. So in other words, any suit must be brought within 2 to 3 years in order to capture that back pay for those wages. And kind of why this topic has been of interest lately is the increases to the salary thresholds. So that happens time to time that the Department of Labor wants to increase the wages as cost of living goes up. The final rule was announced, I believe, in May of this year, that they were accounting for 2 increases. The first was on July 1st, And the minimum salary requirement for exempt employees increased from $35,568 a year to $43,888. So as I'm sure you're aware, that went into effect on July 1st. It is currently in effect. There are pending lawsuits, but as of right now, that is the threshold for exemption. The next jump is for January 1st, 2025, where the minimum salary requirement is expected to increase to $58,656. So that's quite a jump, and will qualify millions and millions of more people for overtime. For nonprofits, this is, can be daunting for those of us with a budget, and everything being a little tight right now. It's something, I know a lot of people are interested in because it really will encompass a lot of staff. However, it is expected, I personally expect that it will not go into place on January 1st. There are pending lawsuits currently about this specific increase. First was the state of Texas sued the United States Department of Labor, seeking a preliminary injunction to prevent the rule from taking effect. This happened before the July 1st deadline. The court granted a limited injunction that blocked the rule from taking effect only for the state of Texas. The court found that the Department of Labor likely exceeds its authority in passing the rule because it excluded millions of employees from a duties-based exemption solely on their salary. So it was the Friday before it went into place, and being in Texas, I believe it was like 5 or 6 p.m. our time that the court made this ruling. However, it was only limited to government employees in Texas. So only people who work for the state of Texas are still at that lower threshold of 35,000. The rest of employees in the United States did, like I said, go to the higher threshold on July 1st. Plano Chamber of Commerce versus Sue, who is Julie Sue, the acting Secretary of Labor. They were a group of trade associations and businesses that filed a challenge to the rule. The plaintiffs requested an expedited summary judgment to obtain a merits ruling before the rule's second deadline on July 1st, 2025. This is why I say a lot of employers do expect that this will get overturned and not go into place. The jump from 35,000 to 43,000 isn't that significant. It can be, but it's not nearly as big as the jump to 58,000. So it was kind of expected that something would happen before that January 1st deadline. And Flint Avenue LLC also sued the acting Secretary of Labor. They're a software company challenging the authority to issue the Department of Labor's authority to issue salary requirements. The court denied the plaintiff's request for a preliminary injunction, citing their failure to show that the Department of Labor's overtime rule would cause the company irreparable harm. But we do have these cases still pending before the court, and we do expect a ruling hopefully before December 31st, but we will see how much advanced knowledge we have. And one of the other reasons why we do expect it to be overturned is that this is not the first time this has happened. In 2016, the Department of Labor proposed a rule that raised the salary threshold from what was at that point 23,600 to 53,972. However, a Texas court, so as you can see, these cases are in Texas as well, which tends to favor the employers. A Texas court blocked the rule, ruling that the Department of Labor exceeded its authority under the FLSA. The court found the new salary level made employees' duties irrelevant for those earning below the threshold. So the precedent is there that the courts could block this rule from going into place before January 1st. Again, like I said, the rulings can come up to the last minute and, nothing is for sure. So it's important to now start looking at your pay scales, your job descriptions, the job duties, in order to see who could be affected should this change and should some of your employees no longer be considered non-exempt, or be considered exempt and now fall in that non-exempt and be entitled to overtime pay. So that's all I had. I don't know if anyone has any additional questions.
Thanks so much, Katie. You gave us all a lot to think about and to consider. So there actually are two questions in the chat. And could you please go over the administrative exemption again?
Yes, so the administrative exemption, again, the rate is $8.44 a week, and the employee's primary duty must be the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. And the employee's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. So this would be your office staff who hold some level of importance where they are working independently and making judgments independently.
That clears that up. Yes. Okay. And is it, if an employee is legitimately classified exempt due to actual duties, but the nonprofit cannot pay the new 58,000 plus rate, can an employer change status to non-exempt and decide to pay overtime if it happens?
Yes, absolutely.
All right, there you go. That's okay. Yes, the slides will be available and the webinar is being recorded, so that will be posted on the WCCF website in the next, let's say, several days, so that we can share that. So just to repeat this again, Katie, the first salary increase as of July 1st is in effect for nonprofits, businesses.
Everyone except for the state of Texas.
State of Texas. Do you think, as you say, you think it may not go into effect on January 1st, but do you think this one would be reversed?
That's a really interesting question.
Thank you.
It would be, putting the cat back in the bag kind of a situation.
Yeah.
It's certainly because these lawsuits, especially that state of Texas, were filed prior to the July 1st, it would reason that any court ruling would date to the entire rule. So when the final rule was issued, it contained both of these deadlines. So if they're saying that the rule violates the authority of the Department of Labor, it should apply to both increases. However, for those of us who raised, certain salaries before the July 1st deadline, as I don't think I need to tell this group of individuals, you can't really take that back after you've given it to your employees. So
True. Okay, good answer. The other thing is, and you don't have to name any names or things, but how active and is the Department of Labor, let's say in southwestern Pennsylvania? Do you know of penalties that have been paid?
I personally am not aware of any investigations or penalties that were ever issued. So my guess would be it would require a complainant. So an employee who feels they should be being paid overtime and are not being paid, filing a grievance. That would be my guess. But luckily, I've never had to any issues with the Department of Labor, but that would be my guess, because obviously they have a very large jurisdiction over the entire country to monitor.
Right. And it does seem that the penalties are stiff, though.
Yes.
Yeah. So we got a couple more questions. if you must increase the salary to the $58,000 rate, which is complying with the law as of January 1st, can a nonprofit redline the employee at that rate so they do not get increases for a certain period?
I don't see why that would be an issue. Technically, if they're not, raises don't have to be given. So I don't, you might want to consult with your own attorney, but I don't see why that would be an issue to cap them at that rate.
It's another question. If you qualify as exempt, does it matter if you work less than 40 hours a week?
No. No, and that's a tricky part about full-time employees. That they should, if they're salaried, it does not matter. If they're not salaried and they're hourly, then obviously they'd be paid the hours worked.
Mm-hmm. Mm-hmm. So what is considered full-time Department of Labor standards?
It's however you define it. So like I said, our office staff is 37 and a half for our residential programs because they can't take a lunch. They're 8-hour days or 40-hour weeks. The Affordable Care Act defines it as averaging 30 hours a week. That's when you qualify for benefits. So it's really your policy.
Okay. So different organizations may have different 30+ hours that they may say.
Yeah.
Right, right. Do we have any other questions, or does someone want to raise their hand? I think and we'll touch base with Katie again if there's been any news about, I'm sure that would be well documented if the Texas case or some other case would stop the enforcement or the enactment of the January 1st, 2025 date. Do you know when? Do you have any predictions on when that would be decided?
My prediction would be sometime in December and probably towards the middle. And we might get it a little bit earlier than expected because of the holidays, but they don't seem to, they like the dramatic effect of reversing these right before that. In 2016, we were prepared to increase everybody, whoever fell under the new threshold, and literally pulled everything the day before because that's how short the reversal came to the implementation.
Wow. Yeah. How do you have a sense and how this is going to impact local charities here?
I do not. And that's, one of the main argument of the plaintiffs is that it takes away this duties-based test and really just makes it seem like overtime hinges just on salary. But the anecdotal complaints are that, they're coming up with this aggregate salary looking at data across the entire country, not region specific. So cost of living varies from place to place. For-profits can raise the cost of their service, of their product. Nonprofits don't have that kind of flexibility to make up for this. So it's of course going to differ from organization to organization, but there's just really no way to tell.
Here's another question. If you're a part-time exempt, then is there a comparable salary threshold for that? For example, normal full-time is 2,080 hours. Is it prorated?
No, the overtime is based on full-time status.
So if you're exempt and part-time, it really doesn't affect you.
Right.
Whatever that salary would average out to be.
Right.
Can an exempt employee choose to decline the increase in salary?
No, I mean, that would be your policy if you wanted to allow them. But it would then put them under the threshold and they would be considered non-exempt.
And then their job description or title may have to change. Is that
Right.
correct? Or,
I mean,
yeah,
essentially, they'd be entitled to
duties?
overtime.
Mm-hmm,
So
mm-hmm.
you can allow them to choose to become non-exempt, but you'd have to weigh the best interest of your agency.
I think it's just going to impact then some smaller charities then.
Yeah.
That, weren't necessarily budgeting for this or can quickly find the increased funds.
Right. And I think, it would definitely impact us. I think with a lot of us are struggling to find employees. And so we have other employees working more than normal. So yeah, it definitely will have an impact if it does go into effect.
Mm-hmm. So we're planning to say it is, but then it may be reversed or
Yes,
not implemented.
exactly.
Say it's not going to be implemented as opposed to reversed.
Right.
Okay, so based on your answer about part-time, can a nonprofit make all full-time exempt people change to part-time status to work less than 40 hours to avoid the change?
So if you're not concerned with them working more than 40 hours, then they would never be paid. So if you have an employee who's currently exempt but makes less than 58,000, but they don't work more than 40 hours a week, if the threshold does raise, you can keep them at the salary they're at. They would qualify technically for overtime, but if they don't work more than 40 hours, they would never earn that overtime.
So that's really the key, is if they're working additional hours.
Right.
But still the base salary, doesn't it need to be 58 plus?
Only if they will be working more than 40 hours a week.
Okay. And I guess every organization has to review that. If their exempt employees are putting in more hours than 40.
Right. Right.
There you go. Yes.
That's who you're going to be concerned with, is those current exempt employees who tend to work more than 40 hours a week and then currently are not getting compensated above their salary because you're not required to. That's who you're going to be concerned with should this go into effect.
Katie, I think your organization has about 900 employees, correct? Or
Yeah, give or
900
take.
plus. And then how many do you think this is impacting?
Off the top of my head, this one would impact just our management team. So we have about 100. So I'd say maybe about 75, 80 people might be up
Still
for discussion.
significant. Yeah.
Absolutely.
Here's a question. If an employee is not exempt, they need to be paid for hours worked, correct?
Correct.
But I think you brought up a good point about job descriptions and actual duties. And are they making decisions for the organization?
Yeah. Yeah, that's, like I said, you'll get the slides and you can, see the words, and, take that into consideration, consult, any attorneys you work with, if there's anyone you're not quite sure about, to make sure you're labeling them correctly, especially if they fall within that, between 43,000 and 58,000, where their status could change.
And I should have maybe said this at the beginning, is Katie is an attorney, but she's not providing us legal advice. She's giving us a general overview of what can maybe be in effect January 1st, but that I think she's brought up some good points about just how to look at the employees' job descriptions, titles, things like that, and see what their real work is producing and how, and that they're overseeing things. There is another question. Do you agree that the jump from 43,000 to 58,000 could also be reduced to an increase, but maybe something less?
Currently, I don't believe that would happen. The courts are looking to whether the Department of Labor overreached by passing this rule. Could it in the future be increased at a smaller increment? Yeah, I believe it will be. That happens from time to time, that it does get increased to a smaller increment. And usually that gets them left kind of alone because it doesn't really affect as many people as this could be affecting.
I know you may just say it's inflation, but why do you think it is such a big jump within a relatively short period of time?
Right. I have no idea. I would say, yeah, the cost of living, the inflation, I don't know. It seems excessive. Like I said, they do look at, national data, which can be very skewed across the country.
Yeah, correct. I thank everyone for participating today, and there's no more questions. The next session in our nonprofit leadership and engagement series will be Tuesday, November 12th, and it will be from Lisa Neal and Amy Trenzo from Southwest Training Services on employment programs that benefit nonprofits, if you're not familiar with that agency. I want to thank everyone who participated today, particularly Katie, and your well-informed discussion here. And I hope everyone has a wonderful day.
Thank you
Thanks
very
so
much.
much. Thank you.